This video will explore key aspects of intellectual property law in Sri Lanka. Welcome back to the channel. In today's video, we will discuss Chapter 17 and Chapter 18 of the Intellectual Property Act No. 36 of 2003 of Sri Lanka. We will explain patent license contracts, the rights of licensors and licensees, surrender of patents, and how patents may be declared null and void. Let's begin with patent license contracts. Section 90 covers the meaning of a license contract. A license contract is an agreement where the owner of a patent, known as the licensor, gives another person or company, known as the licensee, permission to use the patented invention. The license may allow the manufacture, use, sale, or commercial exploitation of the invention in Sri Lanka. Under Sri Lankan law, a license contract must be in writing and signed by the parties. The agreement may also be recorded in the official register maintained by the Director General. Confidential business details do not need to be disclosed. Now, let's examine the rights and restrictions within these contracts. Unless the contract states otherwise, the licensee may use the patented invention in Sri Lanka without limitation as to time. However, the licensee cannot transfer the license or grant sublicenses unless permitted by the agreement. In a non-exclusive license, the licensor may continue using the patent and grant licenses to others. But in an exclusive license, the licensor cannot issue further licenses unless the contract allows it. The law prevents unfair restrictions in license agreements. Clauses imposing unnecessary commercial restrictions on the licensee may be considered void. Allowed restrictions generally relate to time, geography, and quality control. Next, we look at what happens when a patent fails or a contract ends. If a patent application is rejected, withdrawn, surrendered, or declared null and void, the licensee no longer has to continue making payments. The licensee may also recover royalties already paid, depending on the circumstances. When a license contract expires or ends, the Director General records the termination in the patent register. If a license agreement involving foreign royalty payments is considered harmful to Sri Lanka's economic development, the Director General may refer the matter to the central bank. The contract may be cancelled if deemed harmful. Finally, we cover the surrender and nullity of a patent. A patent owner may surrender a patent by submitting a written declaration to the Director General. If license agreements exist, the consent of licensees may also be required for surrender. A court may declare a patent null and void if it is not legally valid. The court may invalidate the whole patent or only certain claims based on grounds like lack of novelty or insufficient description. When a patent is declared null and void, it is treated as though it never existed from the date it was granted. To conclude, Sri Lankan patent law regulates license contracts, protects licensors and licensees, and provides legal procedures for surrendering or invalidating patents. License contracts must be written, exclusive licenses restrict licensors, unfair clauses are invalid, and patents may be surrendered or canceled. Thank you for watching. Please like, subscribe, and share for more videos on intellectual property law in Sri Lanka.